Amen. So, food for thought. I don't know when we get to the discussion section, persons may want to, speak to this.
Hello, everyone can hear me. Good afternoon, brethren. So it's my pleasure to introduce Sister Kiva Reed, who has been a practicing attorney for approximately 30 years. She worked in the lower courts initially, then in the public prosecution department. And in 2002, she transitioned to private practice, where she covers various areas of law, including but not limited to family law, criminal, probate, and land law. So with years of experience and an in-depth understanding of the legal intricacies, she's here to guide us through a comprehensive presentation on how to navigate the complexities of wills and property matters. Without further ado, I present to you Attorney Kiva Reed.
Good evening, brothers and sisters. I think I have too much up here. Okay, before I begin, I must thank Raquella for that introduction and for the youth department for inviting me here this evening along with the family ministries, because when it comes to property, wills, probate, and all that sort of thing, it's very much a family matter. It's a church matter too. It's a matter of stewardship. And they cited a few portions of the spirit of prophecy, and I'll just give you one little one from the Word of God. And that comes from 1 Timothy 5, verse 8. But if anyone does not provide for his relatives, and especially the members of his household, he has denied the faith and is worse than an unbeliever. Okay, that is whether that is in life or in death. So although people may think that subjects like this should not be spoken about in the church, it's all a part of our Christianity. It's all a part of our responsibility as good stewards. Now, when you think of what you aspired to in life, you had dreams of a particular career and what you would like your life to be. I think if all of us were to be honest, a part of that dream in life was to have something. You wanted a career, you wanted a family, but you didn't want to be poor with nothing. Isn't that correct? You're hoping that with the hard work and the education and the discipline that eventually you would have something. A nice car, a lovely home, real estate of some sort, money in the bank. So when we talk about property, although we're going to talk mostly about real estate today and wills, that is really a part of our dream. Okay, in the American society, they talk about having a little house with white picket fence. In the West Indies, it's basically the same, but we want land and property. So this afternoon, I'm not going to give you any legal discourse. If you're looking for a thesis and big words, you're not going to get that this afternoon. I'm hoping that we can talk as a family, and I will try to give you and share with you some of my experience as a legal practitioner and my understanding of the law. There are some particular issues I will deal with in terms of land rights and probate and administration. There's one other topic. I don't know if we'll get time to touch on that this evening, but if we do, I will. First of all, when you talk, I'm speaking only in a Cayman context. Okay, although many of you are from Jamaica, or you may have property in Jamaica, most of the laws are similar, but some are different. So I can't speak for Jamaica, and in particular, when it comes to land, I think Jamaica has a part registry. It's not a complete registered land like we have here in Cayman. All right, so the law is quite different, but some of the things might apply. So this is really for the Cayman context, but I might be able to help to some degree to point you to some areas as in regards to land in Jamaica. Now let's just say, and I'm being practical, you want to buy a piece of land. You've come to Cayman, you've worked a while, been here almost 7, 8 years, and you're hoping to get permanent residence, so you want to buy a piece of land. Or you're Caymanian, and your parents want to transfer land to you, or you've now come out of college and you want to buy that first apartment. You need to know basically what you have to do. So we'll deal firstly with some of the aspects of the registered land law and some of the particulars when it comes to the forms that you need to deal with. It may seem simple to some of you, and it may seem a simple exercise to many of you, but there are some things that a lot of people don't understand, and it could be very detrimental if it is done incorrectly. Brother Colley, I don't know if you are able to bring the stuff up on the screen. Okay, the first document is this one here. I apologize for those black ink stuff there, but I wanted to make sure I wasn't able to identify the person's property. Can you open it a little bit more? Okay, we know that we have what we call the land registry here. Okay, and it's really lands and survey. And maybe I'm thinking old, but it used to be lands and survey department. Okay, I don't know if they've revised the name. But people usually just think about it as land registry. But it's not only that. Say, for example, I want to buy Sister Fletcher's house, and her house is on South Street, and is the third piece of property up there. We not only go and look for the land register, because Miss Fletcher might have said, okay, Sister Reed, you can have my land, and it's 1/3 of an acre, and it's 100 feet from the road, and it's 50 feet wide. Now, you can accept her word for that, but remember, you're putting your good hard-earned money into that. Whether she's a sister or a brethren or a friend, you need to go and find out exactly what it is. So one of the first things you can do is go to land registry and go to the survey department and ask for a map of that particular parcel. Okay, let's say it's 14E parcel 141. You just tell them the parcel you want, and they can bring up on the registry map that parcel. And it will show, I don't know if you can magnify it anymore, Brother Colley. It will show the measurements of the property on every side. Okay, it'll tell you whether it's 150 feet or only 93 feet or whatever have you. So that is important. And in addition to that, you want to go and walk the property and see the markers for the property, okay? In addition to that. But the registry map is very, very important. Sometimes surveyors get it wrong too. So that is important to make sure you look at the registry map to see the size so that you are not buying a piece of property different from what you're proposing to buy. Then the second thing you need to do if you're proposing to buy a property is go and look at the land register. The next document, please. The land register. Or maybe I think I have the land transfer, but let's look at the land register first. Keep going. That's the transfer. Go ahead. I think I had 2 separate documents. It was in the second email to you, the second one I sent, because this one wasn't quite right. So I sent it again, Brother Colley. The land register. Okay, if you can magnify it. Yes, it's ugly because I had to blot out some things. If you can zoom in for me, please. That's very important on this document. little bit over to the left. A little bit more. Okay, I don't know if you can see this, brethren. I'm hoping, but at least it shows some things that you might want to. When you look at the register, and when you go into the land registry, you go and ask for a copy of the land register. You can't just pick it up. You have to go to an officer. They will look it up on the computer. And you give them the block and parcel number, and this is the register. This is the official legal register of land ownership for that particular property. You don't have to guess. In some places, like where I come from, you have to guess who owns it. And you have to do a long title search. Could be hundreds of years to find out who truly owns it. But in Cayman, it is very clear. Whatever name is on that land register is who owns it. Okay? So it's very important to look at that land register. Now, trying to see. Oh, it's not up there. Okay. On the top right-hand column for you, it shows the block and parcel number. It'll be like Georgetown East, block 15, parcel 20-something, and then it'll tell you the size of the property. Okay, and in the middle section there, if you just move it a little bit over, Brother Cully, middle to the top, it is what we call the encumbrance section. And parentheses. It'll tell you of anything that affects that land. Now, I remember a few years ago, I had a lady come to me, and she bought a lovely piece of land in Bodden Town, paid a good bit of money for that piece of land. Then she went to build a nice house and went planning to get it passed, and planning say can't pass it because you have a right-of-way that runs right through the middle of the property, and you cannot get the setbacks from that. So in this apprentices section, right at the top there, in the middle there, it'll tell you what affects that land. Okay, it tells you a right-of-way. That usually refers to the road. If you're on a main road, it tells you that there's a main road in front of it, but it'll also tell you if there's anything crossing the land. And that's why also it's important to look at that first diagram that I talked about in the survey department of the land register, where it has the size of the land and it shows the map. If there is any right-of-way over the land, you will see it clearly on the map. It'll show like a little dotted line across it, which means that there's a legal right-of-way or something that crosses that land. So you'll need to know that. So these are very important because it'll affect how you can develop the land. And also it'll tell you on the far left if it's an absolute title or some provisional title. We don't need to go through that. But those things are important. A lot of people don't know what the situation is. I'm going to take her question, but I need you to hold your questions until I'm finished for the most part. Okay? It depends on what it's indicating, but usually it may say it's a footpath over that property, you know, because your property may be situated, and years ago people used to live in the back there. So they asked the person for a right-of-way, and they went and registered that right-of-way. So it's registered on registered on the land register, and it is also shown on the map. Okay? And if you don't know that, you go and purchase the land, you won't be able to build unless you build in respect of that right-of-way. Now, you can get rid of it, but you'll probably have to go to the people who benefit from it and say, look, man, I can't build anything. Can I move the right-of-way over here so I can build, or something of the sort? But it's important that you look at both the map as well as the register to determine what your rights are. Now, one thing a lot of people don't know about, a lot of people know about the register. They might know about looking at the survey map. But if you want history of the land and also some other things to know about, ask them to give you the parcel file. Okay? I won't tell you all the time it makes a difference, but it's nice sometimes to know the history of the land. Sometimes it also has things in there that are very important for you. The parcel file, they'll go in the back and they'll bring you a file. And that file will give you every document that has passed through that land registry since that property was registered, okay? It'll show the transfer for $15 in 1972 or various things. If there's a trust instrument that affects that land, that trust instrument will be in that parcel file. So if you need other information, you could also ask them for the parcel file. So 3 things. Check your register, check the property map, and also, if you want to, you can go and look at the parcel file and notice anything that affects the land that is reflected on the land register. You cannot, after you buy a piece of property, say, well, I want my money back. I didn't notice I had a right-of-way running through. That won't help you, okay? Because once it is shown on this register, you are deemed to have known. Okay, even if you, oh, I didn't look at it, your problem. Once it is registered on this and shown here, you dog ate your supper, as they say. The property is yours no matter what the condition of it is. All right, so that is in regards to the land register and how you must look at it before you purchase a piece of land. Now, another thing that may not be so complicated is the actual document of transfer if you're purchasing a piece of land or a house or whatever it is. If you can just bring up the transfer of land for me, please, Brother Colley. It would have been in the documents I had before there. The transfer of land. Yes. Okay, if you can go down a little bit. I'm sure if you've bought land, you're familiar with this document. And most people say, oh, you just fill in your name and whatever and transfer it. So it has the transfer of land. Give me the top of it more, please, if you could zoom into the top section. We'll come down. Okay, if you can zoom in a little bit more. I don't know if you can. Okay, it tells you the registration section. So that will be like Savannah, and the block, if it's block 16 Savannah, and the particular parcel for that piece of land. So it identifies it immediately at the top of that document. Then it says we, and that's the owner. Let's say you're buying property from me. So it'll say we, and I would put Kiva Reed, Kevareid. In consideration of $20 million selling this piece of property. Okay, I wish mine was worth that. That's why I say that. But the important thing why I stop with this, I may have written on this transfer of land, Kiva Reed. Nice name, written properly, spelled right, but you have to be careful, again. That's why it's sometimes better to go to an attorney or someone who deals with land transfers. Because if I just put Kiva Reed on this, and I said, here, you got it all witnessed, as we go down on the bottom, everything is done according to what you think is right on this paper, then you take it to land registry to get it transferred, okay? You paid the money already. And they say, oh yeah, I see you have Kiva Reed here, but the land register says Kiva Elaine Reed. They're not going to transfer it. So the name on this transfer form for the person who says they're transferring it must match the register. Okay? That's why it goes back to the importance of having the register. So you make sure when you're doing the transfer document that that name is the same as the one that is on the, spelled the same and is put the same as it is on the transfer document. Very, very important. Then the other part here that a lot of people don't understand. Don't go to sleep on me yet. You're going to transfer the land. It might be you and your good friend transferring the land. You both work hard. You're not married yet, and the two of you want to buy this piece of land that you build maybe a duplex on that you could have for the rest of your lives. It says that you're transferring it to these two persons. It asks, how are you going to hold this land? And it gives you two choices, undivided share or. Yes. I'm sorry. Heard something over. And if it's me and Raquel that own it, I can write a will until the dogs come home or the sheep come home. When I die, it's going to go to Raquel. It doesn't form any part of your estate. If Raquel dies, it goes to me. Even if she wanted to go to her loving husband and children, it still goes to me because it is held in joint tenancy. Okay? So you need to make sure that that's what you want. You can change from shares in common to joint tenancy, but it's much more difficult if you do not consent to break a joint tenancy. Okay? If you do not consent to break a joint tenancy. Okay? So if you and the person get into a row and you don't want him to inherit your land, and you say, I don't want to have this in joint tenancy anymore, you can't just do that. You perhaps need to get to court to break that joint tenancy. So that's very important. You need to know how you're going to hold the land, whether it's joint tenants or tenants in common. And we can go into something else there, but I don't want to bore you in regards to that. But safe to say this. If you're purchasing land from an individual person, it's usually fairly easy, although I've expressed some concerns already that you might want to consult someone to help you. But in particular, if you are buying property from a company, you need to be extremely careful, okay? You either go to an attorney, or when you're going to purchase it, go and visit the land registry and ask them what they will require in order to accept a transfer from that company, because there are things that need to be put in place, which I do not want to go into right now. All right? And another thing, some of you or your grandparents might have left land for you. They might have died eons ago. You don't just leave your land unattended. I'm sure you've heard of quieting rights, prescriptive rights, rights that are obtained through limitation law. And if you have a piece of land and there's certain things happening on it, you have to take action to get it within 12 years or your rights are extinguished. When it comes to prescriptive rights, I'm not going to go into all the details of that, but if someone is using your land, walking over your land for the last 20 years, okay, they live in the back of your property, and for 20 years, you have allowed them to walk over your land to get to their property, okay? You never bother them, they go there, whatever. Now, if you actually give them permission, it's a different story. But let's just say they did it, they didn't ask you any permission, but they were doing it for 20 years. You can't come and fence it and say they can't use it anymore, because they can then go and claim that right to walk over the land because they've been doing it for so many years, at least 20 years the law allows. So don't just leave your land alone, go and check on it. It's not so relevant in Cayman because it's a small place, but in other places you have similar laws that apply. Go and look at your land, see what's going on with it before someone acquires rights against that land. All right. And also, if you're dealing with your grandparents, Granny want to give you the 6 acres in Little Cayman, but she's now 80 and she barely could see. You wanted to transfer the land. Usually you can't just go with Granny and get a friend of yours who's a notary public to sign it and you go to the registry. Many times with persons who are elderly, they require more than that, okay? Because if not, people can challenge that transfer and say she was whatever and she was incompetent in doing that. So many times if the registry knows that the person is elderly or may be possibly not quite strong enough and mentally or otherwise, they would ask for other documents before they proceed with the transfer. All right, and stop telling people you own land if your name ain't on it, okay? All right? If you own the land, your name should be somewhere there. Okay? Wives and husbands especially, you have one, or you bought the land, and one goes and does all the process, and the other one hopes that everything is in order. All right? It's not that you don't trust them. This is also a business, and it affects your rights, your children's rights, whether your wife or husband know what is going on. Okay? See those land documents. See the land transfer. Know what's happening. I've seen many times, and it's usually wives, I'm sorry to say. The husband dropped dead, and they got 15 children to look after. And when they go to the land registry, he sell it from 2 years ago. Or her name was never, ever there. He had it joint with his mother. You understand? So it is important that you, if you're supposed to own land, or you're in a marital situation or whatever, to check your land documents to see that they are in order. You do have rights as a spouse, but certain things will be extremely difficult if one passes. All right. Any questions on that before I proceed to the other heading? Yes. Not until she goes to court, takes out letters of administration, or if he wrote a will, then you'll have to get that probated. If your name isn't on it, you have to go through court and get it probated. It's very expensive, I understand, in Jamaica, and it's going to cost you a couple thousand, well, in Cayman, if you're going to get it, the letters of administration or probate done. So it's much easier to have the property in your name if you're married. Okay, have both names on the property. I like the joint tenancy, but you might have reasons to have it in shares. Any other questions on these issues before we move on? Looks like I'm boring you to death. No other questions? I must have made it clear. Okay. Yes? You can use that mic.
Okay, purchasing the land from, say, you come with everything, your lawyer's working out on it, and you and your brother join, you both come in, and then you pay a deposit on it because everything seems good. Then you realize that the land is owned by the dead father, and the name is not on it, and it's a sibling tag and war stuff.
Okay, that's exactly why I told you to do what I just said before. Once you go to the land register, you will know who actually owns it. Okay, even you don't pay any deposit unless you look on that land register to know who owns it. So you don't go and pay a deposit on a piece of property and you don't know who owns it. Go and look at that land register first. They might tell you that, oh, it's still in my grandfather's name, but I have rights to it and whatever. That's a risk you might want to take. But don't pay a deposit on a piece of property unless you have looked at the land register and gotten it clarified. Yes? Huh? Well, you have to try to get back your money if that isn't what you understood. Okay? And you can take action against them if necessary. Okay? Because they can't be selling property they don't own. But that's not uncommon in this place, because a lot of times land is here and property is owned by dead grandparents and they've just never probated or taken out letters of administration. So you have 40 people who have interest in that land from grandma, but one of those 40 wants to sell it because they say they have rights. That can give you big problems. So you need to make sure that you check into that before you make any deposit. Yes, Brother Jimmy. I can't hear the question quite clearly. That is strictly hearsay. Some of you may need to confirm, but that's what I understand, some land is registered in Jamaica, but not all. So you have to go, I think you have folios and what have you. Huh? Nothing is registered in Jamaica? Okay. So I was giving them more credit than I should have. Okay, go ahead. Mm-hmm. Okay. Yeah, the Cayman Islands did what started the land registry system in 1972. Prior to that, we didn't have registered land here either. And there's a lot of benefits to having a land registry. In my home country of the Bahamas, it's a disaster trying to buy land there. And the lawyers get wealthy off of it. Okay? This is a bit off, but I'm just saying, for example, and I don't know how it is in Jamaica. You can go and say you want to purchase a piece of land in the Bahamas, and they have to do what you call a title search because the land isn't registered. And sometime when they do that title search, they have to go back to the 1800s. They have to leave the Bahamas and go to Key West to find out who really owns that land, that kind of thing. But if you're dealing with lawyers, reputable lawyers who have some knowledge of these things, you might feel fairly safe. But in Cayman, you're very safe when you're buying land because of the land registry system. Okay? I can't speak of all of what happens in Jamaica, but I know they have some level of security in regards to the transfer of land. Questions? Okay. Now, who is going to inherit Mama's part? Okay? We said we need to take care of our families while we're alive, as well as when we pass. I don't know what it is with West Indian, and I'm sorry, it's particularly with West Indian men. I don't know why. I didn't do a statistical study, but this is my opinion. They are afraid of doing wills. It seems like they think that if they do a will, they're going to pass on, or some of their family is going to plot to kill them because they own the will. But it's a part of taking care of your family and taking care of the assets that you have either inherited or that you have worked hard for. So once you gain majority, even if it's a car you have, a little bank account, you might only be 21 or whatever, make sure you take responsibility and write down who you want that to go through. Some people don't worry about it because, well, I know it's going to my mother and father or whatever have you. But it's important to make sure that what you have goes to the persons that you feel deserve it or the persons that you love and want to possess it after you die. Now, there are two ways of doing this. Well, one way is a way that you don't have to do anything, okay? And you can die what you call intestate. That means you die without a will, okay? I don't recommend that, but a lot of times through carelessness, maybe procrastination and some of the other reasons I mentioned, people die without a will, okay? You might be young and think you have another 50 years and then you die suddenly. The law provides for how that property will pass, anything that you own. The law prescribes that in what they call the succession law. So you can go on the website for laws in the Cayman Islands and put in succession law, Cayman Islands, and a section of that law will tell you how property passes if you die without a will. First of all, I'm not going to go down the succession line, but if you're married, if you're without a will, half goes to your spouse, the other half is divided with all your children. Okay, but there's a minimum requirement for your wife or your spouse. Okay, so if you own less than something, if that minimum requirement is not met, all of it will go to your spouse. But I think in most cases that is satisfied. If you don't have a spouse, everything goes to your children. If you don't have any children, then it goes up to your parents. Okay? And also, you have provisions for going to your siblings of the whole blood first, and then your siblings of the half-blood afterwards. Okay, and so on. Cousins don't inherit. If you have nieces or nephews, they don't inherit. So if you don't make provision for a very faithful nephew or niece who has been good to you, work hard. If you don't put that in the will, if you don't have other people, it go into the government. All right? So it's very important, especially for people who are married, don't have children, maybe don't have family. Make sure you get your will done. I was dealing with a very sad case a few years ago. A couple, elderly couple, never had children, but had family that was very close to them, nieces and nephews who took care of them, was there for them. And they were preparing to do their will, and the husband suddenly died. And the wife said she wanted to make her will, but before she got a chance to make her will, she died. They left millions of dollars worth of property. And particularly a nephew who they had treated him almost like a son. I think he might have been able to, well, I don't know if it was treated him like a son, but was very close to, all right, who was there for them all during the time. They're not provided for in the succession law. So rightfully, that has to be turned over to the Crown, unless you might make an application to see if the Crown might give it to you. But very important. Okay? And those of you with children, again, vitally important to make wills. If you have an intact marriage and things are going well, maybe fine. But sometimes you have one parent one way and the other parent the other way, and you die, and you may just say, this is left for my children. But if they're underage, that parent controls everything that you left for the children. Okay? So even although you say you want this to go to your 3 underage children, yeah, it's going to go to them, but not to them directly if they're underage. Whoever is responsible as their guardian is going to control that. And that person may buy all the Mercedes-Benz and say she needs to transport the children to school. Or the husband may say, you know, he needs to travel quite a bit to work, but he's actually taking his wives, his sweethearts and whatever. But I'm just saying, you need to make sure you provide for that. And if you do not want the parent of those children, for whatever reason, to be in control of the funds that you leave for the children, you have to put in your will that you want those funds for the children to be held in trust by that named person. Okay? So that person who you can trust will then control the funds for those children until they become of age. Understood? Also, when you come to making wills, we're going to talk about the execution of wills just briefly. Wills are simple in a way. You can write what you want and sign it. It doesn't have to be a complicated legal form, but it has to satisfy the provisions of the wills law. Simply put, the testator must write what his wishes are. He must do that in the presence of 2 witnesses. In the presence of 2 witnesses at the same time. And the 2 witnesses must see him sign or her sign. Okay? So it can't be a situation where someone is dying on the bed and they say, this is my last will and testimony, and all of a sudden you get dire and you have to run out, and you're a witness, and the person signs it, and you didn't actually see them sign it. Okay? The witnesses must be present, see the person sign it, and both of them must be present, the 2 witnesses at the same time when the testator signs. But that's just one part of it. The persons who witness your will are important. Some people cannot witness your will. If those persons witness the will, it becomes invalid. For example, if Sister Giscombe wants me to witness a will, but she actually leaves half of her estate to me. Okay? But she writes the will. She said, Kev, I want you to come and witness my will. So I witness it along with Raquella. If she passes on, everything that she left to me will not go to me because I witnessed it as a beneficiary. So I'll lose all of my benefits under the will. So someone who is benefiting under the will cannot witness the execution of the will, or their spouse. Okay? So if I'm leaving something for Selena, her husband can't witness the will. All right? Or else it will invalidate any gifts I gave to her. All right? And of course, also, although if you're under 18 or under the age of majority, you can't make a will. But you actually can witness it, but it's not advisable. So it's better to get someone who is of age to witness the will. And you don't want to get someone, I mean, these are obvious things. You don't want to get someone blind to witness the will. Or someone who just escaped from a mental institution or something of the sort. They must be competent and persons. You're going to ask a question? Okay, I'll go on. They must be competent. They must preferably be someone of age. All right, they must not be a beneficiary or the spouse of a beneficiary or a civil partner of a beneficiary. Okay, just a moment. All right, and if you're going to put someone who is, say for example, I've put Sister Fletcher as the executor of my will, meaning that she doesn't inherit from my will, but she will be in charge of my will when I die to make sure that my children and my husband get everything. She's the one who will take control and make sure that they get everything the way they're supposed to do it. So she's the executor of my will. She can witness my will because she doesn't get any benefit under it. But if she does get a benefit, then her benefit will fail. All right? Also, marriage can invalidate a will. All right? So all you nice single people who have your wills all tucked away and what have you, when you get married, that means the will may be dead. Okay? So you may have to execute a new will just before or right after the wedding. Okay, the only way the marriage does not invalidate the will is if when you write that will, you say that I am going to marry Tom Jones tomorrow. And this will takes that into consideration, and it'll make the will valid because it tells you, the will speaks to the marriage happening, so it'll not invalidate the will. Otherwise, the marriage can also invalidate the will, so that's something you need to take into consideration. All right, and of course, if the person destroys it, decides that they don't want this will anymore, and they strip it together, so you can't put it together and say, oh, this is the last will and testimony. If the person tore it up and say they don't want it to be valid anymore, don't try putting it together and taking it to court and say, well, this is it. It won't be valid. Okay? Brother, you had a question?
You answered it. I was going to ask you about the executor, and you answered it. But maybe you can answer this one. Do you need an executor on your will?
Yes, you do. Okay? That is the person who's going to be in charge of your property. It'll be chaos otherwise. Okay?
Meaning if a will was created and it didn't have an executor at all, how does that work?
It can still go ahead, right? Because it expresses the wishes of the person. Okay? So it doesn't mean that it will be invalid because it doesn't have an executor. So the court might appoint it, or among the beneficiaries, they might appoint a person as executor. Well, I'm not sure how, well, if it doesn't have an executor, which I haven't seen, I would think that any of the beneficiaries can go to court to get the will probated, okay? But they'll have equal rights, so they'll have to, what we call, clear off all the other beneficiaries when they apply for the probate. Okay? Yes, Sister Cheryl?
Okay, can an executor benefit from the property on a will?
Of course, an executor can benefit as long as they don't witness the will. Because a lot of times, the executor is one of the beneficiaries. For example, if I have 2 children, or 3 children, or 4 children, but one of them is more responsible, I might make one of those children the beneficiary. I'm sorry. I might make one of those children the executor of the will, but they have just as much rights as the other children under the will. Over here. I would not advise that at all. Not at all. To get someone who can't read and write. I mean, in an emergency, of course they can write their X, but how are you going to be able to determine that that's their X? But I mean, under ordinary circumstances, no. But I mean, there might be dire situations that the court will have to look at it. But for the sake of this exercise, you don't get somebody who can't read and write, okay? Yes? Say that again. Yeah, I've heard that one too. They can still claim, but a lot of people do it just for safety to say that they were recognized. I'm coming to you. But that doesn't make it safe. Okay, if I'm a wife and I'm the big wage earner and I die and my husband has been basically dependent on me to live and I don't like him. So when I die, I make sure he don't get anything. He can still, even if I left $100, he can go to court and say, look, court, I still have a mortgage on the house, and I was dependent on my wife for this all of the years, and whatever have you. We still have children alive. It is quite likely the court would grant him something from your estate, okay, depending on the circumstance. It usually is more successful for a dependent wife because of our culture, okay? But that dynamic is changing, because many times it was the husband who had all of the properties, and the wife had the children and they whatever have, or maybe they even had many women, and they might have left everything to their sweetheart, and the wife with the children at home had nothing. Then the wife could claim and say, look, I have these children, and these are his legitimate children, I have to take care of them. The court is going to recognize it even if he doesn't want to. Okay, they can make a claim against the will. So you might try that, but that doesn't mean it's going to be successful, depending on the circumstance.
What I was going to ask is that suppose the spouses, they're separated, and whatever the wife acquired after the separation, do they have to make provision in the will?
No.
And can the husband, if suppose the wife died, can the husband claim anything after
I'm not
death?
saying he can't claim, but he won't be successful in his claim if they've been separated like that. It's highly unlikely. Is no complete, no, he won't be successful. But usually in the circumstances, he would not be successful if they've been separated all for a long while, and there's no apparent need to maintain that person, okay? You can be separated for a long time, and there was a maintenance order for the wife.
Okay.
Or you could have a maintenance order for the husband, although you're separated. In that circumstances, they could still claim against your estate, okay? But under the usual circumstances where you've gone your way, he's gone his way, you don't really have show any need to maintain him, no, there won't be any successful
Okay, thank you.
claim. Unlikely.
where he said separation and not divorce. Just want to have it clear if that's what
Yeah,
she
she
said.
said, I think she
Right.
meant not divorce.
Is there a limitation as to the separation for that, for what you just said, for it to occur?
Okay, you have two
Right.
different types of separation, you know. You can be legally separated, or you could just be living apart. When you're legally separated, usually all of the rights are gone, okay, of the marriage.
Or there's no length of time for you to be separated?
Um,
Like, for example, 6 months, 5 months, a year, 2 years?
well, if you're going to go to court, that matters,
Okay. That's
okay? That would matter, because if you only separated 2 weeks or 5 months, but if you've been separated 5 years, so that would be significant if they're making a claim, for sure. But also, even if you only separated a month, but it's a legal separation, usually the rights disappear after you have the pronouncement of the legal separation. She has been there, and I didn't call on her, the beautiful lady in the green back there. They want you to come up to the mic. I must apologize, because she's been holding a hand up for a long time. Okay, go ahead.
My question is, what if the witness to your will died before you? What happens?
That doesn't invalidate the will. It won't invalidate the will,
Okay.
okay? The will will still be
So
fine.
if the witnesses die before me,
The will will still be valid,
okay.
okay? Okay, someone kind of complicated the issue there, and I don't know if I can definitively answer that. I don't know, Camille was saying, what if you have somebody who you just, like a wife and a husband situation, you're separated, but you kind of just giving them $100 a month, that kind of thing? Tell me what you were saying.
I was saying that the situation that Sharon raised, it normally happens. It normally happens in Jamaica, where you have like what we call outside kids or bastard kids, where they would be the recipient of like an insignificant thing, just to keep you quiet. So I was just clarifying or adding to what Sharon said.
Okay, that is a horse of a different color, okay? If you have bastard kids, I don't even like to use that term, children who are not born in the marriage, okay? Their rights are equal to the children in the marriage, okay? So if the person dies and they have a will and they didn't include those children, and those children are dependent, the mother can come and make a claim against your estate, okay, and most likely would be successful, okay? If she can prove or have some evidence that there was some support or that the child is in need of that. Just hold on a minute. I have a question and come around here.
So just to clarify, if someone has illegitimate children, but they're dependents, they're under 18, they may have a claim. But what if the child is over 18 and born outside of the marriage?
They have a claim too, but it will be a different kind of situation. If you have a will,
If
they can't.
If there's no will, if there's no
Oh no,
will
if there's no will, they have equal rights. Okay?
for illegitimate,
They have equal rights.
okay.
If you have a will and you didn't provide for the illegitimate children and they are of age, it's unlikely they can make a claim unless they have some, they're dependent because of physical abnormalities or something like that. All right? I'm not saying anybody can make a claim, but I'm talking about making possibly a successive claim for something from the person's estate. All right? Any other questions? Just looking at something just now. Also, when we talk about whether a will is going to be made invalid, Another very important factor that will make a will invalid is if the will was made voluntarily. You know, that's very, very important. Person might be unduly influenced. And you may say, well, yeah, we know that. But particularly for elderly people, all right? The person has money, all of a sudden this person comes around and they treat them so kindly and whatever have you, and after they butter them up good again, they start talking about what they own, and they exert undue influence upon that person, sometimes saying that if you don't do this, I ain't bring no food or something. If you can prove that, that will invalidate the will because of an undue influence, whether by duress or some other circumstance. I saw a hand somewhere. Yes.
I've seen online websites popping up about will making. What is your recommendation on going through a will making website as opposed to going to an attorney or just writing it yourself?
I'm not saying this because I'm biased, because I'm an attorney, but the will making online doesn't necessarily apply to your jurisdiction of the Cayman Islands. A will can be for the state of Florida, and the law in the state of Florida might be different from the state of Michigan and much different from the Cayman Islands or Jamaica. Okay? So the provisions on that will are different, what you need to do on that will. So I would get some advice from a lawyer. Usually it isn't very expensive here to get a will drawn up. Doesn't cost you thousands of dollars, depends on where you go, whether you go into the ivory towers or what have you. But usually it isn't very expensive to do that, just to make sure. And sometimes you can just draft a will and ask a person who has knowledge of wills to just look at it and say, is this okay, what I need to do, and they won't charge you.
I think grandchildren is a part of the family. What if, like a wife and husband have like 4 acres of land. They have 3 grandchildren, and the husband may die and say the land is for Mary. When Tom and John out there didn't get it, when the wife died, Tom is to get it, and Mary and Jane doesn't get any. Does the other two have any action to take?
Okay, the grandchildren only get rights through their parents. Okay? So if their parents are alive, the grandchildren don't inherit unless the grandparents name them in particular. But once their parents are alive, they will inherit through them, otherwise no. Okay?
Question, when somebody draws up a will, can we have multiple copies of it? Or there has to be just one original copy?
It's a good question.
Can I
Because
share?
I'll be honest with you, most times we make a few original copies. Okay?
Can
And
I
you could-
share a scenario with you while
Yes.
I ask?
Uh-huh.
And just a word of caution to everyone.
Uh-huh.
So my father remarried before he died. So before he died, we always knew where his will was. He always told us where his will was. Always saw it. He always said if something happened to him, this is where the will is. After he died, his second wife took the will. So when we as his children went to look for the will, we could not find it because it never occurred to us to have another copy. And when I reached out to the attorney, he said, hold on. Even he knew that my father had where he had his will in the house.
Mm-hmm.
So now having another parent who's still alive, she's like, yes, I have a will. And I'm like, okay, where is it? So I don't want to be in a scenario again where the original disappeared. So is it possible to have copies and give to more than one individual?
Well, a copy, when I say copies, a copy is different from the original.
Okay.
Okay, that's why I say many of us as attorney, we do more than one original, so to have the ink and everything. So if one disappears, you have an, quotes,
So the
original
attorney has.
copy. Uh-huh.
Okay.
Okay?
But there's no way, like for instance, my mom has 3 children. So if she does a will, there's no way for us
Tell her to
have some
tell her to
sort-
register the will.
Okay.
Like in Cayman Islands, if you have a will, you register it if you're afraid of
Register
that.
it. Okay,
You know, go ahead, and I'll give you another scenario too.
yeah.
Okay? So if you're worried about that, go and register the will, okay, at the registrar of companies, same place, but it's a place where they call it the registrars. You can go and register your will there. So it won't disappear then, because often people who don't like the contents of the will, they'll get rid of it because they know if the will is not there, they can inherit. So it is important to make sure that it's in safekeeping. Other persons will put it in a safety deposit box, and the key is kept by an independent person. So if the person passes, the will is still in a safe place, okay, and isn't accessible to any and everybody.
Yes, ma'am. Is it a wise thing for a parent to make a will and it is known to everybody who is all the beneficiaries?
Yeah, unless you got a bunch of wicked children who can try to kill you. But sometimes it's good because there'll be no surprises at the end. Okay, but you know, I really don't see anything wrong with it to tell them what is there and what isn't. But if you know it's going to cause controversy, you don't have to tell them anything. All right? Because if you know that I have Tom, Dick, Harry, whatever children, but only Harry responsible, and I know if I give the other 2, it's gone. So I'm not going to tell them that, look, only Harry getting most of the land. That's going to cause a controversy.
Right.
So in that circumstances, you might not disclose the contents of your will.
Right.
So it's a matter of what the circumstances are.
To me, I think that could be a very dangerous thing to do. You know? Because sometimes, you know, parents generally have a little bias towards children. And you know, the behavior of the children, etc. Because if you know that that child is a waste. So, but another part of it, miss, is that instead of making the will, why not give the child, while he's alive, whatever?
Okay, that if I remember. Go ahead.
Not a question, sis. Just on the point you mentioned earlier about drafting up the will. Just for persons who may have properties in Jamaica, there is already an outline for the will in the legal terms that is done by the government printing.
Excellent.
You can get it at any stationery, just fill in the blanks and take it to be registered.
Excellent.
Right.
That is very good. Okay. Trying to keep my trend of thought. The gentleman just mentioned that maybe instead of willing the property to your children, you can just give it to them. Again, it depends on the jurisdiction you're in, but if we're talking about the Cayman Islands, you can do that, but it's not always advisable. For example, if you only have one house, okay, and you don't want to wait for your children to fuss over it and have to go through probate and pay a lawyer and all that sort of stuff. And you say, okay, I'm going to turn over my house to my children. Okay, and down the road you want to get married and they don't like your spouse, your new spouse. And one of them turned to a druggie and he wants his property now. You don't have any rights there again. All right? So you have to be very careful in transferring your property to your children. Now, what some people do is they hold the property in trust. And they have a trust instrument that says that, look, I hold this property in trust for Kevron, Kristen, Casey, and Errol, and whatever. And so when I pass, they don't have to go through court. They just go and get it, go to the registry and get it. But the trust instrument says that as long as we live, we can do anything with this land. We could even take away the land from them. And they cannot interfere for my enjoyment with the land. And if I marry, they can't. You understand? You have to make sure you cover yourself, but in those circumstances, you need to get a professional to help you how to do that. But it actually will make it easier for your children because they don't have to spend thousands of dollars with an attorney to get it probated through the court, and it can just be turned over to them after your death. But in Cayman, fortunately, if you feel you can trust your children or you have so much land that you just want to give them some, so you'll have some to yourself. It is easy to transfer property to your children because you don't have to pay the regular stamp duty. Okay? It's usually, what, 7.5% or 5% for Caymanians or something of the sort. But if you're giving it to your child or grandchild, the stamp duty will be waived. Okay? So they don't have to pay that heavy price. But in some other places, and I don't know if Jamaica is one of them, there are other things may come into play if you're transferring it to the children in your life. Okay? So, yeah, some taxes may come into play and all those kind of things. So, or property you may own in the States, all of those things you need to look at and get some legal advice before you transfer to the children. Because even in the States, they refer to, rather than transferring the land to your children while you're alive, put it in a trust. But you would need to see a legally competent person to do that properly. So a hand over here.
I was just asking, what age can you give the land to your children?
You can give it to them at any age. Okay, but if they are minor, nothing could be done on that register. Okay? If I say, look, I'm going to give this to my granddaughter, Kelsey Reed, and her name is put on the register, nothing could happen on that property until she comes of age. All right? So it freezes the land until that child comes of age. All right? So you don't really want to do that. That's why you put it in trust many times for the child. It'll go to their sibling, or who is next on intestacy. If it's a child, it'll go to one of your other children. Okay? All right. It'll follow the laws of the succession law of intestacy for that child. All right? Any other questions? All right, I'm just going to touch on something just a little bit. I don't want to go into divorce and all those kind of things. But one thing that a lot of people don't understand either, pension. Okay, I'm just touching on these things. In Cayman, if you're married at the time of your death, your pension goes to your spouse. Punto final. Okay? Someone say, I see some people get so upset. What you say? Because they're not getting on with their spouse. But whether it's the public service pension or under the public service pensions law or under the national pensions law, if your spouse is alive at the time of your death, that person gets your pension. Under the national pensions law, they get 100%. I put a sticker pin in this, but if I remember, under the civil service pensions law, it is for the spouse and the minor children that inherit your pension. I was surprised that they didn't do it with the national pensions law too. Within the civil service pension is for the minor children and the spouse. But I was surprised to find out in the last year that under the civil service pensions law, the spouse only get half. That really grieves me, man. After you've worked all these years and if something happens to you, your spouse only gets 50% of what your pension is. That seems like a real gut punch for those of you who work in the civil service. Somewhere in cyberspace. I guess it stays in the fund, you know. But I was surprised to find that out because I thought they got whatever your benefit was, but they don't. Okay? I don't know all the details, but I understand, for example, if you were getting $1,000 every month and you die, your spouse only gets $500 on that monthly amount. Okay? I was surprised to find that out from a client. Yeah? And I stand to be corrected if that's not so. But I know under the national pensions law, with the other pensions, although they don't mention the minor children, you get 100%. Okay?
What if there's another name on the pension form?
It don't matter. The law prevails.
Okay.
The law prevails. Okay? So,
Kiva, just to clarify, you just mentioned the civil service pension or the national pension for the 50% beneficiary if the spouse died.
I'm stand to be corrected because I honestly didn't look on the provisions under the civil service pensions law, but I was speaking with a client in a probate and administration matter, and the person clearly told me that their husband was getting X amount, but after he died, that person was only able to get 50% of what he got on a monthly basis.
For the civil service?
Yes, civil
Okay.
service. Yeah, so that's the basis on which I say that. Okay, but I know under the national pensions law, you get 100% of what the pension is. So that you need to know. That may not affect other things like what your shares are in credit union and that sort of stuff. You can name who you want the persons to inherit. Unless you have any other questions, I think I've covered what I wanted to deal with today. If you have any other questions that might affect those things, I am willing to deal with them. But the important thing we must always keep in mind, brethren, that we are stewards. And whether in life and giving a portion to the service of Christ or in death, you must also remember that whatever you leave should be used for the service of Christ. So it is important too, if you can, to leave something for the church or to evangelism after your death as a part of what you want to leave behind. Some people resist that because they say, I've been given tithe all my life, why I need to do this. But it's a matter for you, it's a gift. If you want to make sure that something is secured for God's work after you pass. But this is just a personal opinion. Some people give everything they have to the church and not one thing they leave for their family. I have a problem with that, but that's just a matter of opinion because the Bible tells you that you must take care of your relatives, and if you don't care of your household, you're worse than an infidel. So let's remember that. Thank you for your attention, and unless you have any other questions, I'll sit down, and it's been a privilege, and I think most of you are awake now. Some of you fell asleep, but bless you. Thank you.
All right. Thank you so much, Sister Kiva. We have had much to chew on and to think about, as it relates to our property. We thank you, Sister Kiva, so much for the wealth of information that you've shared with us. And it's good information because as a people of God, we should not be ignorant. There's so many important things that constitute our whole life. And this is an important part of it. Thanks again, Sister Kiva. It's almost time. Sun sets about 5 minutes to 7, I think. So we have about 20 minutes to wrap up. Let's sing a hymn. And we close out. Work with my musician, make sure that we are on. We're going to sing Abide With Me, Fast Falls the Evening Tide, number 50. Abide abide with me. Fast falls the evening tide. The darkness deepens, Lord, with me abide. When all the helpers fail and comfort flee, help of the helpless, oh, abide with me. Verse 4. I fear no foe, with thee at hand to bless. Ills have no, there's no bitterness. Where is death's sting? Where grave thy victory? I triumph still if thou abide with me. Amen. I thank you so much, Roger. I'm really impressed. I'm really impressed to be able to just pick a song. And typically, younger persons with some of these older songs don't get it that well. I'm really, really impressed, Roger, and I trust that you'll just continue, because we need to be seeing more young musicians in church playing on Sabbath. Thank God for blessing you with the skills, Roger. Let us stand together as we close out. I want to encourage you as we go throughout the course of this week to allow the Spirit of God to lead our lives. Let's walk with Him as He carries us, as He journeys with us through the ups and the downs. We do not know what the week ahead has in store for us, but we can trust God irrespective of what comes. Thank you for a well-spent day in your house of worship. We thank you that your Spirit has been with us, and we have been truly blessed. We thank you for every aspect of the service this morning, throughout the course of the day. We thank you for the knowledge we have gained, and we pray, Father, that all that we have learned today will draw us closer to you and help us to be good citizens, to be able to take care of our families well. Father, as we enter this new week, we trust you, God, because you have always been carrying us. You've always been leading our lives. And so we have no fear for the week that's ahead, because we know that you are with us. Continue to be with us, I pray, Heavenly Father. Walk with us, and may we listen to your voice as you speak to us and guide us into truth. Hear us, we pray, because we ask it in Jesus' name. Amen. What's that song again? Savior Breeze. Let us sit quietly and sing the song, Savior Breeze and Evening's Blessing. Savior, breathe an evening's blessing, ere we pose our spirits yield. Sin and want we come confessing, thou canst save and thou canst heal.
Brethren, before we leave, just Sister Selena, just wanted to remind us that tomorrow we have VBS beginning, and Sister Selena is leading the charge. Let's work with her, brethren. She wants persons to come out, adults to come out tomorrow and the rest of the week to help us to manage the children. And if you could stay behind if you are able to do that, to help her to complete the decorations, that would be very helpful. Thanks so much.